Today, we will reflect on the history of the legal struggles that the NAACP attorneys, mainly Thurgood Marshall and Charles Hamilton Houston, that sought to dismantle the Jim Crow segregation and discrimination laws. And we ponder, how was the Supreme Court Brown v. Board of Education decision, which ordered the desegregation of schools, the culmination of decades of litigation? What persuaded the Supreme Court to rule that the previously decided Plessy v. Ferguson decision, which stated that separate but equal facilities for blacks and whites were acceptable, violated the 14th Amendment? And how did the efforts to upgrade the premier black law school at Howard University enable black attorneys to further civil rights for blacks? Please, we welcome interesting questions in the comments. Let us learn and reflect together. At the end of our talk, we will discuss our conclusions and the sources we used for this video. Please feel free to follow along in the PowerPoint script we uploaded to SlideShare, which includes illustrations. Our sister blog includes footnotes, and both include our Amazon book links. Before the courts started to slowly turn away from segregation in the Jim Crow legal system, public opinion in the South just had to shift, which happened ever so slowly. During Reconstruction, immediately after the Civil War, many whites joined the Ku Klux Klan and other white terrorist groups to keep the Negro down through violence and intimidation, and often lynchings and murders of blacks went unpunished. There were entire towns that resisted the federal Union troops sent into the South to guarantee the civil rights and voting rights of the freed slaves. Also, the 1619 Project features many horrid stories of the injustices blacks suffered in the Deep South before the civil rights era of the 60s. This opposition to civil rights in the South was not monolithic. For example, the Tuskegee Institute in Alabama, founded by the black leader Booker T. Washington in 1881, initially relied upon funds raised from the local Alabama business community. It helped that Tuskegee was a university town that was more tolerant of blacks. During the Reconstruction and Jim Crow eras, lynching was so endemic in the South that often these gruesome events would be advertised in the newspapers, and body parts of the blacks who were lynched were sometimes displayed as souvenirs in store windows. It was rare for a Southern jury to ever convict a white man of even the most heinous crimes committed against a black man back in the day. If the blacks called the sheriff to complain, often they were the ones arrested. It was also common for Southern sheriffs to pick up young black men and charge them for vagrancy so their services could be sold to plantations, mines, the railroad, and other businesses as convict labor, which in many cases was even worse than slavery. Theodore Roosevelt's Attorney General tried to combat this scourge with minimal success. Afterwards, state investigations in Georgia and elsewhere eventually started turning public opinion, until the Justice Department under FDR during World War II started eliminating this inhuman treatment of black convicts, as Jim Crow was a propaganda coup for the Nazis. By the 20th century, black attorneys who volunteered their services to the NAACP started to chip away at the Jim Crow legal system. Thurgood Marshall's devotion to the NAACP cases forced him to continue living at his parents' home, as his practice had few paying clients. His mentor, Charles Hamilton Houston, convinced the NAACP to pay Thurgood a salary. They would be the only paid NAACP attorneys for many years, although by mid-century there were 4 other attorneys on staff, and there may have been more by the 1950s. And this bare-bones legal staff accomplished a great deal, winning many cases before the Supreme Court. Although the black leader W.E.B. Du Bois was a co-founder of the NAACP, he was not involved in the administration, but was rather the editor of the Crisis magazine. He had little to do with the legal department. His name is not included in the index of the book we're reviewing, although our 2 NAACP attorneys often wrote articles for the Crisis magazine. But before blacks could win these legal victories, they had to have a good education. In 1929, Justice Louis Brandeis, the first Jewish man appointed to the U.S. Supreme Court and an advocate for those abused under and by the law, ruefully told Mordecai Johnson, the president of Howard University, "I can tell most of the time when I am reading a brief by a Negro attorney. You have got to get yourself a real faculty out there, or you're always going to have a 5th-rate law school. And it's got to be a full-time and a day school." Johnson agreed. Although Howard University was the premier colored law school in the country, it was not accredited. If the attorneys graduated from Howard University were to have any chance in challenging the Jim Crow legal system, they had to be just as competent as their best white lawyers opposing them. He knew just the person who could make this leap. One of the most brilliant colored lawyers in the country, Charles Hamilton Houston. Houston's family was part of the Negro aristocracy of Baltimore. Houston's father was an attorney. He worked for the federal government before starting his own practice. They sent Houston to the school at Amherst, where he was the only black student, where he graduated with honors. At Harvard Law School, he was the first African-American member of the Law Review, and he earned an advanced law degree. Houston was appointed assistant dean, but he ran the day program since the white school dean taught at the night school. As a first step, Charles Houston pressured lackadaisical professors to resign and replace them with top-notch black attorneys. Then he tightened up the admission standards, accepting only blacks graduating from accredited colleges. Then, in 1930, he made the big leap, seeking permission to close the night school. Coming in the depths of the Depression, this was highly controversial. All of the white professors resigned. Many of the black professors also protested. Most of the alumni had attended night school. They did not want to Harvardize Howard. And Johnson assigned the duties of the dean to Houston, who added tens of thousands of volumes to the student law library. Half the student body were not able to make the transition. Many were unable to make the financial sacrifices necessary. Houston slipped money to some students who were struggling financially, but those who stayed became top-notch attorneys who could advance civil rights issues in the courts, who could be social engineers, who could use a law to change the law. And most importantly, in 1931, for the first time, the American Bar Association awarded Howard University Law School full accreditation and approval for the very first time. And Dean Charles Houston became a mentor to the studious, hard-working Thurgood Marshall, who was at the top of the class. Now, our author, Ron James, said that in Houston's presence, Marshall sparked like a match touched to flame. He admired the dean's singular devotion to excellence, his contempt for good enough, and this admiration kindled within him these same traits. He enjoyed repeating Houston's maxim, "Lose your temper and you lose your case," which was especially good advice for colored attorneys in those trying times. Another favorite maxim was, "Doctors can bury their mistakes, lawyers cannot." Soon after graduating as valedictorian at Howard University, Thurgood Marshall accompanied Charles Houston on a fact-finding tour of the Deep South for the NAACP. This was a dangerous journey. Many blacks were lynched in the Deep South. Ron James notes that contrary to popular belief, most lynchings did not result from the allegations of black men assaulting or even flirting with white women. Only 16% of lynching victims were accused of sex crimes. Many breached one of the South's countless rules of racial etiquette. There were black women who were massacred at the rope, women like Mary Turner, who was seized in the Georgian night, strung up on a tree by her ankles, sliced open with a buck knife, and forced to watch upside down as the men pulled her unborn baby from her screaming insides and killed it first. Houston later testified to Congress that in 1933's lynchings, the most striking feature of nearly every press photograph is the number of women and little children present at the festivities. And Charles Houston spent more and more time on the NAACP legal cases, as did Thurgood Marshall after he opened his private law practice. After several years, Houston left Howard on a leave of absence to work on the NAACP cases, and in time both he and Thurgood Marshall accepted a modest salary to become paid legal counsel for the NAACP. They worked closely together on many cases. Houston would be a mentor to Marshall until he passed away. However, Houston often sought to give credit to his brilliant understudy, allowing him to make the public appearances, knowing that one day he would take over the reins of the NAACP's legal struggle against the Jim Crow legal system. They were a resource for black attorneys fighting for civil rights all over the country. Houston and Marshall would personally litigate only a small portion of the appeals for justice that were submitted to the NAACP. And the first item on the agenda was battling the separate but equal doctrine in black schools. And this is referring to the Plessy versus Ferguson decision. And this was an NAACP test case in 1896 where Homer Plessy, a black man, bought a first-class railroad ticket and was arrested when he refused to move to the blacks-only carriage in violation of the state Jim Crow law. The majority Supreme Court opinion ruled that separate facilities for whites and blacks were permitted as long as they were equal. and Justice Marshall Harlan wrote the famous dissenting opinion. And the white race, Harlan wrote, was undoubtedly the dominant race in wealth, power, prestige, and achievements. However, the Constitution itself is colorblind. The thin disguise of equal facilities was not an innocuous separation of the races, but is rather an expression of racial dominance rooted in slavery. The law assumed that blacks were so inferior and degraded that they cannot possibly allow to sit in proximity to white persons. In my opinion, Harlan added, the judgment this day rendered will, in time, to be as pernicious as the Dred Scott opinion. Justice Harlan correctly predicted that the decision would unleash a flood of statutes segregating every realm of Southern life. In fact, segregated facilities were almost never equal. In the early part of the 20th century, the NAACP did not battle segregation. The issues that took precedence was opposing lynching, improving due process and voting rights for blacks, and improving the economic conditions of blacks. Houston and Marshall agreed to take on the case of Donald Gaines Murray, who had graduated from mostly white Amherst College and had applied to the University of Maryland School of Law in 1934. He was eminently qualified, but was rejected solely because they did not accept Negro applicants, violating the 14th Amendment. They said that blacks could instead apply to attend Princess Anne Academy, which had no law school and had mostly high school level classes. Marshall argued that since a law school for blacks did not exist in Maryland, the Plessy president dictated that Murray be permitted to attend the University of Maryland School of Law, and the local judge agreed, ordering that Murray be allowed to attend. The university appealed, and the appellate court ruled in Murray's favor, which meant that Marshall could not appeal a case to the U.S. Supreme Court, which meant that this case would not create federal precedent. And Murray graduated from law school and got along with both school officials and his fellow white students. In an article in the NAACP Crisis magazine, Houston explained what they were demanding. Equality of school terms. In other words, the black school year should be as long as the white school year. Equality of pay for Negro teachers. Equality of transportation for Negro school children at public expense. Equality of building and equipment. Equality of per capita expenditure for education of Negroes. And equality in graduate and professional training. Marshall would represent William Gibbs, who served as both teacher and principal of Rockville Colored Elementary School in Maryland, who was paid less than half of his fellow white teachers. He petitioned for equal pay in 1936. A Maryland court held in favor of Gibbs, and the county announced that it would equalize the salaries of black and white teachers and principals over 2 years, since the county had to raise revenues for these raises. Although this did not set federal precedent, it made equal salaries more palatable without overturning the entire Jim Crow legal system. In Missouri, Lloyd Gaines applied to the Missouri School of Law and was at first accepted, but was then rejected when the registrar, S.W. Canada, learned that Lloyd was black, advising him to either attend the colored Lincoln University, which had no law school, or enroll in a school in another state, with Missouri reimbursing his tuition. This was inherently unequal, in part because an out-of-state law school would not teach Missouri law. Houston decided to file a case seeking to have Gaines admitted to the law school as Missouri ex rel. Gaines versus Canada, emphasizing that he was really representing the interests of all blacks in Missouri. When the court hearing commenced, there were very few blacks witnessing the trials, since several lynchings deterred many from attending. But unlike in Maryland, in Missouri both the local and appellate court ruled in favor of the law school, arguing that Plessy sanctioned the separation of the races in all circumstances. The case was appealed to a U.S. Supreme Court where FDR had appointed several judges sympathetic to civil rights. The Gaines case set a valuable precedent, stating that Missouri could not shift its responsibility to furnish equal facilities and opportunities to its citizens to other states, ruling that he should be admitted to the Missouri School of Law. Our author Ron James notes that Gaines weakened the holding of Plessy versus Ferguson in two crucial respects. First, Gaines demonstrated that the court would no longer defer to Southern states' dubious claims of providing an equal education for their black and white citizens. The Chief Justice's opinion made clear that the judiciary henceforth would closely examine whether a defendant state provided equal education to its residents regardless of race. Second, by declaring the Gaines' educational right to be a personal one, the justices preempted any state's claim that it need not establish a substantially equal school for 1 or 2 black students. Sadly, Lloyd Gaines was having a difficult time supporting himself and was receiving death threats. While he was preparing to attend Missouri School of Law, he disappeared in New York City. His body has never been found, but his portrait now hangs on the wall of the Missouri School of Law. And they also fought many cases fighting lily white juries and racial injustice. When a white man who had been threatening black women about town was killed in Paducah, Kentucky in 1938, the police arrested a 19-year-old black youth named Joe Hale, who vigorously protested his innocence. His lawyers failed to quash his indictment because the county had excluded blacks from jury duty for 50 years. The account suggests the evidence tying him to the crime was scanty. When both the local court and appeals court ruled against Joe Hale, Houston appealed the decision in Hale v. Kentucky to the U.S. Supreme Court. As Ron James notes, Joe Hale's murder conviction was overturned, and the Supreme Court's unequivocal language left no room for obfuscation. The Constitution did not allow courts to exclude eligible citizens from jury service on account of race. In another 1938 case in Montgomery, Alabama, 2 white sisters were beaten horribly while picking flowers, and one of them later died. The police immediately swept through the adjoining black neighborhood searching for suspects. They arrested Dave Canty based on the testimony of a fortune teller seeking the reward offered by the governor. When he protested his innocence, they whipped and starved him in an isolated cell for a week until he confessed. The author notes that this was progress. In prior decades, he would have simply been lynched. At trial, he protested his innocence, saying he never met these white women, and that he confessed only because he had been beaten and starved for a week. He was convicted and sentenced to death. This sentence was upheld by the Alabama Supreme Court. Thurgood Marshall appealed to the Supreme Court, which ruled that confessions extracted by beatings were inadmissible evidence in order that the case be retried. This time he was found guilty and sentenced to life in prison, where he died many years later. In a prior ruling, the Supreme Court had ruled in Grovey v. Townsend that a whites-only Democratic primary in Texas did not violate Texans' right to vote because the Democratic Party preventing Negroes to vote in the primary was not an act of the state. And the Supreme Court proclaimed that this was wrongly decided in an appeal filed by Marshall in the Smith v. Allwright case that excluding Negroes from voting in the primary elections was an act of the state, especially since there was not meaningful competition in the general election. By the mid-1940s, our author Ron James notes that Thurgood Marshall was engaged in a subtle dialogue with the Supreme Court. The justices knew him, they were comfortable with his astute deference and easy insistence, and he had come to understand them. By their questions, asked and unasked, they told him their concerns and advised him where and how they were willing to step next. Although Houston still worked on NAACP cases, and although Marshall often asked his advice, he had returned to private practice a few years before. He would pass away in 1950, before the Supreme Court issued its Brown decision. Another series of famous cases were the cases involving racial restrictions and deeds. Spotwood Robinson, a student attending Howard Law School, wrote a thesis arguing that racist restrictive deed covenants, which forbade selling homes or real estate to Jews or blacks that neighbors found objectionable, should become unenforceable. His study included data on the actual effects of racist covenants, how they skewed neighborhoods and cities. Thurgood Marshall was impressed and commissioned him to expand the argument for use in litigation in 1944. Marshall was coordinating as best he could the efforts of 36 black attorneys filing cases attacking these restrictive covenants across the country. He convened a meeting in Chicago of anti-covenant lawyers in 1945. 2 cases where neighbors sued to block the sale of homes to blacks and where the state courts ruled for the restrictive covenants were appealed to and consolidated by the Supreme Court. And one of them was Houston's case, Hurd v. Hodge. 3 of the justices recused themselves from the case because their houses were subject to these racially restrictive covenants. The Truman administration filed a brief supporting the NAACP's position. These covenants were not mere private transactions immune from public scrutiny. Ron James notes that Marshall contended that state action commenced when buyers and sellers entered into a contract because the force of their agreement depended on the judicial enforcement of the contract. The Supreme Court ruled unanimously that in granting judicial enforcement of the restrictive covenants, the states have denied petitioners the equal protection of the law. These petitioners had been denied rights of ownership or occupancy enjoyed by other citizens of different race or color, which violated the 14th Amendment. And all of these cases led up to the case that's the most famous, Brown v. Board of Education, which ordered that public schools be desegregated. Quite often when the Supreme Court ruled in favor of civil rights for blacks, many states ignored these rulings, which led to appeals on issues that were already settled, which tried the patience of the justices. In some cases, cities simply closed pools and parks rather than integrate them. When a lawsuit was filed in Missouri by a black seeking entry to the White College School of Journalism, the state legislature shut down both the white and black schools of journalism. Many state legislatures in the Deep South belatedly sought to appropriate more funds for black schools, pools, libraries, and parks. But the facilities were far too unequal, so these efforts were often far too little, far too late. And the case that likely paved the way for overruling the separate but equal Plessy doctrine was the Oklahoma case, McLaurin versus Oklahoma State Regents for Higher Education. George McLaurin had sought a doctorate degree in education, but was not only denied admission because he was black, they also did not offer comparable in-state education for blacks. When a federal judge ruled in his favor, the state reluctantly admitted George into its program, but insisted on humiliating him. The school officials forced him to sit in the hallway so segregation of the races was maintained in the classrooms. He had his own grim area in the cafeteria, and he could only work at a desk hidden away from everyone else when he used the library. The NAACP appealed his case to the Supreme Court. The lawyers in Texas stated that Marshall's brief did not cite any case contesting the Plessy separate but equal doctrine, because there were no opposing cases. The Supreme Court unanimously ruled that the University of Oklahoma should not only admit George McLaurin, they should also cease humiliating him. But the Chief Justice refused to overturn Plessy. Now was the time to end segregation once and for all, Thurgood Marshall announced to a key meeting of the members and attorneys of the NAACP in 1950. In future cases involving public schools, he planned to use a psychological study compiled by Kenneth Clark. In this study, foot-tall dolls, 2 brown, 2 white, were presented to black children aged 3 to 7. Ron James recollects that the Clarks instructed each black boy or girl, "Give me the doll you like to play with, then the nice doll, then the dolls that are a nice color." Black children across the country displayed an unmistakable preference for the white doll and a rejection of the black doll. When he asked one black boy which doll he didn't like, he pointed to the brown doll and he blurted, "That's a nigger, and I'm a nigger." And Dr. Wikipedia has an interesting discussion of the doll test in its page on Kenneth and Mamie Clark. The NAACP was appealing several cases, including blatant inequalities in South Carolina and Virginia public schools. But Marshall also chose to appeal a case in Topeka, Kansas, Brown v. Board of Education, because Topeka had arguably equal school facilities for both blacks and whites. Marshall would instead argue that black segregation itself harmed the black school children. These cases were consolidated by the Supreme Court. Chief Justice Fred Vinson scheduled oral arguments for December 1952, but the justices were hopelessly fractured, and Vinson did not want to abandon Plessy. A second round of oral arguments were scheduled for December 1953, but Chief Justice Fred Vinson died of a heart attack in September. After attending his funeral, Justice Felix Frankfurter quipped to a friend, "This is the first indication I have ever had that there is a God." President Eisenhower appointed longtime Republican Earl Warren as Chief Justice, and he later said that this was his life's biggest damn fool mistake. Earl Warren convinced his fellow justices that this needed to be a unanimous decision. Warren said this, summarizing the court's opinion: "Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does." Now, John F. Kennedy nominated Thurgood Marshall to be a judge on the U.S. Court of Appeals for the Second Circuit in 1961. And his successor, Lyndon Baines Johnson, appointed him to be the Solicitor General in 1965, and then appointed him to the Supreme Court in 1967, where he would serve until 1991. Thurgood Marshall was familiar to the justices since he presented oral arguments before the Supreme Court on many prior occasions. Even though many northern and border states complied with the Brown decision, resistance was widespread in the South. In Little Rock, the public schools were closed for a year. Eisenhower had federalized the state National Guard to protect the black students selected by the NAACP to desegregate Central High School in Little Rock. On the day of the Brown decision, black teachers warned their students to go home as soon as possible. This was a warning worth heeding, as an angry white man was prevented from raping one of the future Little Rock students that day. In the Brown decision, the Supreme Court had signaled that it sought to promote civil rights and dismantled the remaining remnants of the Jim Crow segregation laws. And this decision enabled the protest movements publicized by Martin Luther King, which we discussed in our reflections on his life in the Montgomery bus boycotts, in the lunch counter and freedom bus ride protests, and the protests in Birmingham, the I Have a Dream speech, and his famous march in Selma, and his protests in Chicago, and his assassination in Memphis. Martin Luther King conferred often with President Lyndon Baines Johnson, and they coordinated their activities to enable the passing of the Great Society legislation that furthered civil rights, voting rights for blacks, and fought poverty. And now we'll discuss some conclusions and the sources we used for this video. Ron Jane's Root and Branch is an excellent history of the decades-long legal struggle against Jim Crow segregation and discrimination. He includes interesting short biographies of Charles Houston and Thurgood Marshall. There were several instances where his life was in some danger, although they do not have any personal experiences with attempted lynchings. What struck me was how stubborn many in the Deep South clung to the Jim Crow segregation system. Many of the lawsuits I described had to be fought multiple times when many politicians and policemen in the Deep South simply ignored the Supreme Court decisions. Also included were discussions about the NAACP's battles against lynching. In the closing pages, we learned that more conservative justices were appointed to the Supreme Court, and Justice Thurgood Marshall wrote many dissenting opinions that rolled back some of the civil rights reforms. The YouTube description includes a link to our PowerPoint script that we uploaded to SlideShare and also our blog. Please support this channel by sharing this video with your friends and by clicking on the like and subscribe buttons and by clicking on the Amazon links to purchase any of the books we discussed, which will earn us a very small affiliate commission. And please consider becoming a patron of our channel. Plus, we will host special discussion groups for our patrons. Plus, you can click on the Meetup or small M icon to participate in our online discussions, where we practice our future YouTube scripts. And please click on the links for other videos that will broaden your knowledge and improve your soul.